Takes us up to George W. Bush. After 9/11, he issued a military order authorizing the creation of military tribunals, claiming he had inherent power to do that. It's a long story. I ended up writing 3 amicus briefs on the case that went to the Supreme Court, the Hauenstein case, decided in 2006. And one of the things I pointed out that the Justice Department claimed the President has inherent authority to do this because of the John Andre Tribunal in 1780. This was the British trial, British spy with Benedict Arnold. So I don't know how good your history is, but 1780, you're not going to get much presidential power out of 1780. You're not going to get any executive power out of 1780 because there's just the one branch, the Continental Congress. So that was struck down.
Didn't have the Constitution then.
Didn't even have a Constitution. But we did have, the John Andre trial was tried pursuant to statute, to articles of war passed by the Continental Congress. So it always had a legislative base, not a presidential base. NSA surveillance, after the New York Times broke the story that the administration secretly had been conducting surveillance in violation of the FISA Act of 1978. The administration offered 2 arguments. One was inherent authority, that the President has this under Article 2, but they also argued that the President has it by statute, namely after 9/11, Congress passed the authorization for use of military force, and they claimed somewhere it was in there. But you don't have a freestanding statute, FISA, which is the exclusive means for national security surveillance, and have it somehow amended or something by implication by another statute. You can't do that. Another argument I won't go into much, but the Justice Department defended inherent power for the President on NSA surveillance under the, quote, sole organ doctrine. It's a 1936 decision, Curtis Wright, that is totally taken out of context what John Marshall said back in 1800. I won't go into it. I've written on it. Anyone has interest, they can email me and I'll send it to you. Last 2 points, secret legal memos under this administration. This year, in March 2008, the administration released a memo that John Yoo had written in March 2003. 5 years later, they release it. It's about 80 pages or something. You read through it, and it's legal reasoning. There's nothing in there that you can see that's sensitive or classified or anything of the kind. And if there were anything sensitive, somebody's name or something like that, a source or method or something, then blacken it out and let the memo go out for the legal reasoning. Otherwise, you have an administration operating on the basis of secret legal memos. Only those with access to it would know what it was. And you can't even have the administration operating legally in the face of documents that are withheld from policymakers. My last point, state secrets privilege. This is something that when someone goes to court, private parties go to court to challenge what they feel are illegal and unconstitutional actions by the President or by the administration. The administration in court will say that we invoke the state secrets privilege, which means that this case cannot move forward at all. You cannot get any access to any documents. You cannot pursue this anymore, because to do so would risk the disclosure of information damaging to national security. So you stop it in its tracks. And that means that an administration, this one or anyone, could act illegally and unconstitutionally, and there's no way in court you could ever mount an effective challenge. I wrote a book 2 years ago on that case, United States against Reynolds, 1953. And it was a case where B-29 exploded over Georgia. Widows of the civilian engineers on board sued to see if there had been negligence by the government. And in district court, the right thing was done. The women wanted the official accident report, and the judge said, you either give me the accident report to read in my chambers, or you lose the case. And the government wouldn't give it up, and the government lost. And the Third Circuit in Philadelphia said the same thing. You either give it to the trial judge in chambers to look at, or you lose. The government didn't do it. and the government lost. It goes to the Supreme Court in 1953 in the Reynolds case. And the Supreme Court, without ever looking at the accident report, accepted the word of the administration that it had state secrets in it. Well, in the 1990s, that accident report was declassified and released, and you can read it. There are no state secrets in it. So the Supreme Court was misled. In 1953, announced the doctrine, which is still there today, the state secrets privilege. Just to finish up the story, the three widows went back to court about 5-6 years ago, and they lost at every level. And the Third Circuit, with Samuel Alito, part of the panel, said that we recognize there are no state secrets in the accident report, and we recognize also that the document has evidence of negligence by the government. But there are three things in there that are, quote, sensitive. And the three things were the plane carrying classified information has to fly at 20,000 feet. Well, I looked at newspapers the day after the crash, and all the newspapers said the plane is flying at 20,000 feet, so that's not exactly a sensitive information. Said also that it's the 3,150th Electronics Battalion. Again, if that's as sensitive as something, you can blacken that out. The women were not interested in that. They were looking for negligence. And the last thing, which was sensitive to the Third Circuit, was that the plane carrying this information, this classified equipment, the plane has to be a bomber. Oh, that's why we call it a B-29. I'll stop, thanks.